Study Session 2, The Status Offenders in the Juvenile Justice System. Introduction. Until recently, almost every state or country treated status offenders and juvenile delinquents alike, referring to them as either wayward minors or delinquent children. Early legal designation of youths who violate the law because of their minority status are now referred to as status offenders. This study session will therefore examine the characteristics, reforming status offense laws, and increasing social control of status offender. Learning outcomes. When you have studied this session, you should be able to 1. Point out the characteristics of status offenders. 2. Highlight the juvenile justice reforms. 3. Discuss the increasing social control over juveniles. 1. What is status offender? A youth who violates the law because of their minority status or commits any delinquent acts such as truancy, running away, theft, incorrigibility, etc. can be described as a status offender. 1.1. Characteristics of status offender. Status offenders are characterized by the following features. Coburn and Klein, 1982. 1. Status offenders are usually not detained or incarcerated with delinquents. They can be transferred to secure facilities if they are repeatedly unruly and considered uncontrollable. 2. Status offenders can be picked up by the police and brought to a police station. They can be petitioned to the juvenile court, where they have a hearing before a judge and come under the supervision of the probation department, the court clinic, and the treatment staff. At a hearing, status offenders may see little difference between the treatment they receive and the treatment of the delinquent offenders sitting across the room. 3. Status offenders are directed to the juvenile court when it is determined that their parents are unable or unwilling to care for or control them and that the offender's behavior is self-destructive or harmful to society. 2. Juvenile justice reforms. The National Council on Crime and Delinquency and the U.S. Federal Government's National Advisory Commission on Criminal Justice Standards and Goals have called for reform of status offense laws. National Council on Crime and Delinquency, 1972. That is, it recommended removing status offenders from the juvenile court. The following recommendations to reform juvenile justice were made. 1. That the due process reforms, whereby the constitutional rights enjoyed by adult defendants in criminal courts should apply also in juvenile court. 2. That treatment without trial should be avoided, pointing that children were being sent to custodial institutions for treatment without the safeguards of formal due process, including a lawyer to represent them and the right to cross-examine witnesses, and that the juveniles could also be transferred to adult courts without a formal hearing. 3. That the juvenile court must provide the essentials of due process when transferring juveniles to adult court. This is so because juveniles are entitled to the same basic constitutional rights enjoyed by adults in any hearing that might result in their commitment to an institution. 4. That the court preserve the confidentiality of juvenile court records. Although it is agreed that information about a case that is lawfully obtained from an independent source could be published. 5. That a juvenile's acts of misbehaving, ungovernability, or unruliness which do not violate the criminal law should not constitute a ground for asserting juvenile court jurisdiction over the juvenile committing them. 6. That status offenders should be removed from the jurisdiction of the courts altogether, and that status offenders will best be served not by juvenile courts but by dispute resolution and mediation programs designed to strengthen family ties, since status offense cases are rooted in family problems. 7. That more serious and violent juvenile offenders are being removed from the juvenile justice system in favor of criminal court prosecution. A majority of states have added new crimes to the list of offenses for which juveniles may be transferred to criminal court. 8. Traditional confidentiality provisions are being revised in favor of more open proceedings and records. For example, publicizing the names as well as crimes for public scrutiny, releases of past records to appropriate law enforcement officials, and fingerprinting for future identification are all necessary procedures in the war on flagrant violators. Regardless of age, local, place, and citizens have a right to know the identities of the potential threats to public order within their communities. 9. That state correctional administrators are faced with increasing pressures to develop new programs for juveniles. This is so because since nearly all states now send juveniles sentenced as adults to the Department of Corrections, this means that there are more young inmates whose needs and vulnerabilities require special attention. 10. However, a special category of youthful offenders has been identified to distinguish more serious offenders from their delinquent peers. Although they have committed serious crimes and are housed in secure facilities, they are offered more extensive programs and services than their adult counterparts. Bureau of Justice Statistics, 1997D. 3. Increasing social control over juveniles. Those in favor of retaining the status offense category point to society's responsibility to care for troubled youths. Others maintain that the status offense should remain a legal category so that juvenile courts can force a youth to receive treatment. Many state jurisdictions, prompted by concern over serious delinquency, have enacted laws that actually expand social control over juveniles. McDowell and Loftin, 2000. These enacted laws that expanded social control over juveniles are 1. Curfew laws, and 2. Parental responsibility laws. 3.1. Curfew laws. Curfew laws were imposed on children for getting in trouble. Beginning in 1990, there has been an explosion in the passage of curfew laws aimed at restricting the opportunity kids have for getting into trouble. A survey of 77 large U.S. cities found that 59 of them have curfew laws. McDowell and Loftin, 2000. As a general rule, the courts have upheld the use of juvenile curfew laws as long as a. The language of the statute shows a compelling government interest for use of the curfew, and b. The language of the curfew law is consistent with this narrowly defined interest. Curfew ordinances must also allow youth to be out during curfew hours under certain circumstances. For example, in the company of their parents, coming or going to work, school, in the event of an emergency. Evaluations of the benefits of curfews yield mixed results. A survey of more than 400 police agencies by Andra Bannister and her associates found that most had curfew ordinances in effect for several years. In the majority cases, police felt that curfew was an effective tool to control vandalism, nighttime burglary, and auto theft. Those jurisdictions that did not have curfew laws reported that their absence was a result of political objections rather than perceived ineffectiveness. Contrary to these findings, some research efforts have found that after curfews were implemented, Victimization levels increased significantly during non-curfew hours, an indication that rather than suppressing delinquency, curfews merely shift the time of occurrence of the offenses. Moreover, both juvenile victimization and juvenile arrest rates do not seem to decrease significantly during curfew hours. 3.2. Parental responsibility laws. Since the early 20th century, there have been laws aimed at disciplining parents for contributing to the delinquency of a minor. The first of those was enacted in Colorado in 1903, and today 42 states and the District of Columbia maintain similar laws. Siegel, Welsh and Senna, 2003. The laws of parental responsibility over juvenile delinquency allow: 1. Parents to be sanctioned in juvenile courts for behaviors associated with their child's misbehaviors. 2. Parents to reimburse the government for the cost of detention or care of their children. 3. Parents make restitution payments, for example, paying for damage caused by their children who vandalized the school. 4. Parents as well as children to participate in counseling and community service activities. The parental responsibility laws further stipulate that a. Parent may also be held civilly liable under the concept of vicarious liability for the damages caused by a child. B. Parents can also be charged with civil negligence if they should have known of the damage a child was about to inflict but did nothing to stop the child, for example, when they give a weapon to an emotionally unstable youth. C. Parents should be held responsible for the illegal acts of their children. For instance, since 1990, there have been more than 18 cases in which parents have been ordered to serve time in jail because their children have been truant from school. However, civil libertarians charge that these laws violate the constitutional right to due process and seem to be used only against lower class parents. They find little evidence that punishing parents can deter delinquency. Study session summary. In this study session, we examine the characteristics of status offender and what the status offender is all about. We also discuss the varying recommendations of juvenile justice reforms in which status offenders can be removed from juvenile court. We further looked at the increasing social control over juvenile in which parents were held responsible for their children's misbehaviors. These were discussed under A. Curfew laws and B. Parental responsibility laws. End of study session 2. Thank you for listening.